policy and procedure exists to assure that licensure, blah, blah, blah.
So other than that, is everyone in agreement with this section as far as moving on, or is there some supplemental suggestions with the remainder of this section?
I think it looks good.
I just want to double check on including trauma-informed care in subsection A. I know there was some back and forth on it. I put it there for discussion purposes, but if there's no objection, I'll leave it there.
I don't think we need to include that there. Just again, I think there's a better place to memorialize that.
I'll add it to our parking lot for other potential places to discuss. Thank you.
And we're now moving on to 1405 healthcare staff procedures.
And this is another one of those licensure things. There does need to be a responsible physician. Again, one person responsible for administering all clinical decisions, and in facilities, check me out, Kristen, see if I get this right. Again, I like to pretend I know medical stuff. Not every person providing healthcare is a physician. You have nurse practitioners, you have physician's assistants, nurses, RNs, LVNs, all types of other people. So this gives I think this is in line with a community standard. So if people other than a physician are providing healthcare services, they are licensed and operate within the scope of their healthcare.
Well, so this, yes. And for instance, what this allows for is, for instance, a registered nurse is not allowed to diagnose or start treatment unless they have orders from a physician. But this allows for a written standardized procedure, written and overseen by the medical director or the MD, that allows them, based on their licensure, to start, to write orders and start treatment as indicated per the standardized procedure. So that allows them to work independently, and the physician oversees the procedures and allows the nurses to work in that capacity.
So different from the healthcare administrator, who's like the more of a policy level person. That responsible physician is where the buck stops for the medical decisions, for the clinical decisions.
Right. So a good example would be, a youth comes in and has symptoms of like an upper respiratory infection, for instance. There could be a standardized procedure in place that allows the RN to diagnose that and start treatment if the physician isn't on site. Does that make sense? Okay.
Is everyone okay with, oh, I'm sorry, we have a hand up.
Well, I just had a question. This sentence, when it says, when this is done, the function or service shall be performed by staff operating within their scope of practice. I was wondering if it would make sense to add and as permitted by their credentials, or is scope of practice like, does that define sort of your licensure?
Yeah, that defines it. You don't need to add
Okay, thank you.
per your credentials, because the way to think about it, the Nurse Practice Act, for instance, is very clear when it comes to the different level of licensure between, like, for instance, a registered nurse and a licensed vocational nurse. There's different responsibilities that they can take on, if you will. So.
Okay, I think that self-explanatory there, so I think, is there any objections or additional comments for this section?
Okay,
Okay, let's move forward to 1406, healthcare records.
any comments on this one from anybody? Joni?
I just have a question about copies of previous health records, and this really kind of dovetails into my concerns with the next section about confidentiality. So in my mind, I think, like I've said, medical records are distinct from like mental health records. And so does 1406 K refer to, when it says previous health records, does it include previous mental health records as well?
It could. So let me give you an example of what I mean. So if we have a youth that comes into the facility and they are prescribed a psychotropic medication, our nurses are going to need access to those orders, and they're going to need access to that information in order to continue those medications, right? So oftentimes, as is the case in the program I work in, that's integrated, right? We have psychiatrists giving orders to the nurses who are then passing the medications. We have nurses making referrals to the mental health staff, that sort of thing. Copies of previous health records could also include emergency department reports, copies from pediatricians, if there's any specialty care that that youth has received. It could also include copies of psych evals that our team might need to adequately care for the youth on site.
Thank you.
Oh, Amanda, why?
Yeah, I think that I also kind of read this certainly as being very specific related to healthcare records and not behavioral healthcare records. And with as Kristen was saying, that there would be some crossover that the medical staff would have. But it's also written in access to the medical and behavioral mental health records. You know, we maintain our own records that, because in our county it is we are all umbrellaed under healthcare services, so we do have some continuity of care. However, we always get signed written releases of information to be able to share information with healthcare services. So I don't know if there's something we want to leave the behavioral health record mention in there, or then suss out all of the where it should really be separate and distinct.
Can you say that
cannot.
last part again, Amanda? I'm not sure I heard you correctly.
Yeah, I'm just, I mean, are we going to choose to leave it as it's written with the implication that this is all about healthcare records, physical healthcare records, as you noted that there are some crossovers that you would normally have in there. And to my mind, it does not include the mental health, the full complete mental health records, because we keep that. And share that either with MOU information sharing agreements or continuity of care, or through youth signed releases of information. So it's either we're going to kind of leave it as it is, or kind of expand out and convolute it all to really include the mental health portion of the records as well. And that's because we've kind of been embedding in all the previous sections, the mental health part as by the mental health director or the designee. But to me, I read this all as healthcare records, not mental health records.
So are you making the distinction between mental health records being like the case notes, the therapy notes, all of that, not necessarily the assessments or the diagnoses, things that need to be accessible in order to continue treatment, such as medication and things like that? Does my question make sense?
No, it does. And I mean, I think this is part of the struggle about, I mean, if I have a previous mental health diagnosis that may or may not impact my life now, is that a necessary part of my treatment profile? In our system here, and I think in your system as well, if there's a psychiatric medication that's provided by the nurses, there's obviously some sort of continuity of care that has to happen, and that record is disclosed for continuity of care purposes. I so again, I'm not trying to convolute the issue, but I also want to kind of be consistent with what we've been doing throughout the whole entire process of embedding mental health into all of these healthcare records. And I would think that we have our own mental health procedure that we don't disclose records as just a part of everyday course of business unless there is a need.
So in your program, in your facility, are you completely separate from the medical staff? Like, are you physically separate, and you are?
Yeah, our healthcare. So in San Joaquin County, we're all under the umbrella. Well, jail medical, i.e. correctional health, is underneath healthcare services umbrella. So you have healthcare services, you have mental health, you have correctional health. You have a bunch of other programs too, but even if we get a youth to sign a release of information to be able to talk to correctional health about their mental health, which is usually about communication, right? So because we are separate, organized, we have separate chart systems, we have totally separate systems. We do obtain releases of information just to make sure that that the client, the youth, is aware that we are communicating about those mental health and the medication needs, which also includes release of information to probation, to the court, and all of the entities, because we are voluntary services and not mandated services.
Right. I think all mental health services within facilities are voluntary. They're not, you can't mandate that. The youth doesn't want to participate.
All right. And I also go to what the court says about the secure youth treatment, and they think that, they can mandate somebody to that. And that's a whole separate conversation. But anyway, I'm fine with leaving this really the way it is, but because we essentially do all of these things, the
Right.
medical staff. So I don't know. I like I said, I don't want to overcomplicate it. Looks like Melinda has a question.
Well, Amanda's points made me think of a new question, which is, do we have comparable language in the regs? And I'm sorry if I can't lay my hand on it, but that addresses mental health records or behavioral health records. And if not, do we need that? One of my points was going to be, just as a matter of practice, I don't like and/or. You actually mean one thing or the other. And it's much better as a form of plain language communication to say which one you mean. And if you mean it doesn't have to be both, it's your option. You can ignore the health part and just do the mental health, or ignore the mental health, and that you have to, that's actually not, I think, what we mean here. So I don't think we mean it could be or, and you can ignore everything that says healthcare. I think we probably mean and. But if we mean and throughout, when we're saying health service, all the stuff about healthcare, do we mean mental health care as well? I think we should, if we don't have another protection. And the other point I wanted to make was, we had comments about adding a .0, which would be the contact information for community providers, which I also think is a really good idea, to foster continuity of care.
Amanda F.
Okay, just to wrap back up, about copies of previous health records. There was a couple questions. Again, it goes back to Joni's original point of breaking up medical versus mental health. Our healthcare definition means behavioral, medical, mental health, and dental.
Correct.
So with the intent of this section being the facility being responsible for maintaining these records, would there be any issue with clarifying copies of previous medical and behavioral/mental health records? Because I can't imagine, even if medical is separate from mental, the facility in itself is still required to maintain those records, correct?
Right. Well, the facility doesn't maintain them. The individual providers maintain them.
provider
So
does.
it would be maintained in accordance with all confidentiality laws that are applicable to any healthcare setting.
And so what I would say is that if we added to the top a distinction that medical and mental health records are kept, because they're different kind of domains, they're cousins, if you will. So on-site healthcare, the healthcare administration, behavioral health director will keep medical and mental health records. Boom. And then in the section in the access to the medical and or behavioral mental health records shall be controlled by the healthcare administrator and the behavioral health administrator.
But I mean, certainly don't want to interrupt you, but I just want to point out, like we just established, that it includes medical, dental, and mental health. And so if we're only calling out medical and mental health, that leaves dental off. Do you know what I mean? So I don't know that we need to get that specific with it. I think that this captures it.
Yeah, if everybody feels like it captures, because operationally at the end of the day, changing a word here and changing a word there is not necessarily going to change what I do. We're still going to provide appropriate services, and we're going to maintain all of our records and stuff like that. So sorry for taking us down a rabbit hole that we didn't necessarily need to go down.
No worries. There was one more recommendation, I believe, Ms. Bird, to add subsection O. Is that from one of our attachments, correct?
And what was subsection O?
It was
I believe
attachment B. It was
Attachment
the community healthcare providers. I'm trying to get my
Attachment B, page 14, I believe. Have it here. Let me paste it on screen so y'all can see.
I think if you're gonna include that, you should include a statement that says if known or to the extent available, because I can tell you that that is not always readily available information that we are able to get. Okay. Are we done with that section?
I think so. Everyone, agree? Any other questions?
Look at us, we are flying through this stuff.
Move on to 1407.
Before we get started, we're about halfway through. Do people want to take a quick 5-minute break or push through?
5-minute break, please. I vote for a
Right.
5-minute break.
All in favor? Aye. Okay, great. 5-minute break. Thank you.
With HIPAA and all other applicable state and federal laws related to information sharing and confidentiality. Is there anything else that anyone wants to look at in this section, Joni?
So I actually think that this is like a critical part of Article 8 and is like really essential to a successful SYTF. I actually have, and you know, I have to say, I think that issues around confidentiality, particularly with mental health treatment, is really fraught in this kind of situation. So I'm trying to cut and paste what I have here. It was too big to cut and paste by itself. I think that this is where it becomes really clear that there should be a distinction between mental health records and medical records. And we need to be, legally, there is a really big difference between youth who are pre-adjudication, youth who are post-adjudication, and youth who are ordered to do mental health treatment as a term and condition of their probation. So because of that distinction and because all youth in secure track programs are youth who have been many times ordered to do treatment, I think it's important that we kind of tease out all those different scenarios and talk about how privilege and confidentiality apply to mental health records for youth, like undergoing each of those different, parts of the juvenile justice process, if that makes sense.
So the requirement of the court that a youth participate in some form of treatment doesn't alleviate the need for a release of information in order for the information about the treatment itself to be shared. So I think in most jurisdictions and situations where we have youth who are participating in treatment programs with providers who then are working with probation to ensure that the youth is getting the treatment and participating in the treatment in a meaningful way, there are ROIs in place that allow for the providers to share information with the appropriate permission, whether it's the youth and or the guardian and or whoever. So
You know, this is one of the main reasons why I thought it was important to have a defense attorney in particular on this subcommittee, is because, you know, with any individual youth that I represent, I may, with respect to releases of information, you know, I may say, don't sign the release, or the advice may be, look, all of your mental health history can be disclosed, not just to the mental health provider, but to the court, to the district attorney. You just got to be aware of that, right?
Any proper ROI will always have a section that delineates and designates that a person can specify information that they do not want shared. So if you don't see that as part of an ROI that any of your clients are being asked to sign, I would question it, because there should always be a clause or a section that allows the person to say, I don't want this specifically shared.
So I actually think that with respect to the psychotherapist patient privilege, oh, and Amanda, why I see, I don't know if, feel free to interrupt me because I have a lot of thoughts on this. But with respect to the psychotherapist patient privilege, when it's specifically ordered by the court, when the court says you must participate in PTSD, well, let me reframe this. Let me reframe my comments and kind of let you know where I'm coming from. So I represent youth who are in these secure youth treatment facilities, and I've seen two different scenarios. So one is where I have a youth who is really struggling in juvenile hall, and is struggling because there is some identified mental health need, right? And the behavioral health feels that they cannot communicate, or that they're very, very limited in terms of what they can communicate with juvenile hall staff. So the communication in a situation where a kid's behavior is kind of devolving, or they're what is that word? Dysregulated. You know, I think that the psychotherapist patient privilege, which is kind of what is driving a lot of the issues about sharing information, permits, at least in that circumstance, the mental health clinician to be able to communicate some information, some very circumcised information, for the purpose of the treatment for which the youth is supposed to be getting therapy, right? And there's a legal mechanism to do that I think needs to be outlined in the regulation, because otherwise the default is we get a release of information and it has to be all voluntary. And if we don't get a release and it's not voluntary, then we will not share this information, because that is the safest, broadest interpretation of the law instead of a more nuanced interpretation of the law. But to do that, I think you really need to make a distinction between mental health records, and you need to make a distinction between when those mental health records are generated before a court order to participate in therapy versus after a court order to participate in therapy.
So you've said a lot in order to unpack some of that. So Amanda may have different opinions about this, but I don't think that, again, the court designation of whether or not a youth participates in treatment in any way negates the need for an ROI in order to share that information. And I understand, you know, logically what you're saying, but the laws are above me. And I, you know, in terms of the confidentiality laws and why they exist and where they came from. But the other piece of it, in terms of, you know, information sharing within the facility, where we have potentially a safety concern about a youth and their behavior within the facility, that's very different than, you know, being able to share the treatment records of a youth who's been court ordered to participate in treatment, which, by the way, my opinion is that that's a very tricky thing, right? Because you can't mandate that a youth meaningfully participate in anything. If they're going to participate and get something out of the therapy, they have to be willing and able and want to be there. But that's a whole separate issue. So in terms of this section, and Allison helped me out here, I think that the intent of this specific section is to be, broad enough to capture that the health records that are kept within the facility are not, they are kept in line with HIPAA and all other rules, laws, and regulations that pertain to health records, right? They're separate from facility records. They're not maintained in any way alongside facility records. And no one on the facility side has access to these records.
That's my understanding too. Oh, sorry, Amanda, why? This is one of those sections where there are so many applicable laws, and I think you said that, Kristen, like, these are above you as a healthcare administrator. This is just, again, making sure that the facility policy and procedure reflects those applicable laws. It's going to be, the facility is beholden to these laws, even if there weren't such a regulation. This regulation just calls out the requirement for policies and procedures. I don't know if that's helpful or not, but that's, I see it in the same way. Amanda, why?
You're right. There's a lot to unpack. And then, as Joni mentioned, there's different instances where different rules apply. So always in the instance of safety, of crisis, issues of confidentiality can be suspended for the course of treatment. So if we have somebody, linking someone to appropriate level of care. So let's say we have a youth who did not sign an ROI, so I can talk to probation, i.e. detention. So, and then this youth says that they're suicidal. And if we can't safety plan, I would have to break confidentiality to either get detention staff to take the youth to an appropriate mental health crisis intervention, or to put them in to develop some sort of institutional facility safety plan protocol. Then there's the issue also of, irregardless of whether or not the youth has signed a release of information to be exchanged with the court, if the court orders us to release our records, we have to release our records, because essentially that's a subpoena. So there are different instances, and most of the youth that we provide services to do sign and give us permission to exchange information. And we always, if there's some questions, whether the district attorney wants information that comes through the court, then we refer youth back to their attorneys to decide whether or not that would be an appropriate release of information that they would want to sign. So I think in the spirit of this section, it is talking about basically we shall keep our own records based on our own legislative or industry standards of confidentiality, what HIPAA says about electronic health records, and that it shall be shared, shall be appropriate to the treatment planning program needs. I don't know. I have mixed feelings about it. On one hand, we could interpret that because existing laws, if you will, HIPAA, etc., already govern these kinds of things, then we don't, it's embedded in the language that we don't share unless we have those types of things. But then there's these other caveats. So I don't know. I come from an embedded model, so we're here all the time. So if a detention officer sees my staff talking to a youth, they know that they are on some level receiving some sort of mental health services, which on HIPAA then would say if if I'm practicing outside of the facility, then just the mere acknowledgement to somebody that yes, that they are receiving services is a violation of HIPAA. So I think that my explanation didn't really give a whole lot of answers. It just kind of laid out a little bit of my concerns or lack thereof. So
I just want to distinguish too that this section, the 1407, is talking about information. It's not talking about records per se. 1406 was talking about records. So 1407 is simply talking about information and pointing out that services are to be delivered in a confidential manner, assuring that youth have the ability to receive confidential healthcare, whether it's mental health, dental, or medical. And then setting up a framework for the sharing of that information, whether it's with the court, with probation, with custody staff, in terms of treatment planning, program needs, and the protection of the youth.
And legally, medical records enjoy, mental health records enjoy different protections than medical records do. This,
Not always.
well, substance use treatment, diagnosis and treatment information really requires a separate, everything that's related to 42 CFR. So
Mhm.
there's layers and levels within behavioral health as well.
and this confidentiality provision, the way it's written, does not describe it as the way that you've described this is the way that's been described is, these we're beholden to all of these laws about confidentiality. That's above me. That's it, kind of. But that's not the way this is written. The way this is written is we're going to make policies for the multidisciplinary sharing of this information. This will include how we share this information with the court, supervision, staff, probation. I mean, and it kind of goes on into other instances where sharing that information is appropriate. That's not consistent with when we're talking about the psychotherapist patient privilege versus the medical privilege. And so I think, this is a complicated legal area that this is where I think the legal concerns kind of intersect with the delivery of therapeutic services. And I think that youth in all SYTS would be better served if we could tease some of those situations out and have them included within this confidentiality provision, to be clear about it. And I mean, the example I gave earlier was, when mental health is not sharing information, but the reverse has happened where mental health shares too much information and the therapeutic relationship is undermined because, mental health didn't understand the parameters of what would be appropriate to share with both staff and the court and whoever would be appropriate. And so I think here it would be helpful for everybody to be able to outline what the legal parameters of that, of sharing information would be. Just as a side note too, where it says policies, procedures shall address the provision for providing information to the court. It says child supervision staff, but I think that the definition is youth supervision staff or something like that. Like, there's just some minor language definition changes, I think, where the language has changed in the definitions, but not here in the body of the.
Yeah, we'll take care of those administratively. What happened in the last go round, if not every regulation was changed, it wasn't open and we didn't change them, but we'll fix all that in this go round. Thank you.
So in terms of A, I think we were just for Amanda F. We were looking at, I believe, Jonah, you wanted to add some legal language in there in terms of options with information sharing, some type of side note to A.
I mean, I had a lot, look, I think that this is this is really complicated. And there are a lot of problems with even the language that I'm suggesting. It's super complicated. And I think it deserves a lot of thought, and somebody else needs to be looking at this as well. I think though that, you know, and I'm open to different ways of looking at this. I just think that the way that it's written here is also problematic. And so we need to have kind of an in-depth discussion about how we deal with confidentiality of records. And again, there is a big difference between mental health records and medical records in how they're treated in court. And so, you know, this is an well, okay, so I see Meredith's hand up, so I'll let Meredith speak.
I guess what I want to echo is I think this is really complicated, and maybe it merits being something that like gets worked on and brought back to our meeting next week. Just to start with, A appears to be covering both health information being shared externally with the court and probation staff, and non-health information being shared to health staff. That's so much in A, and it's not clear. That last sentence, the nature and extent of information shared, and then it creates a standard, it shall be appropriate. That last sentence, who knows which category of information it's referring to? Is it the case file information or the health information? I'm hoping it's the case file information, because it's otherwise creating a substantive standard for sharing health information where there's so many other laws. But the point being that A needs to be broken down. It's not clear. And to Kristen's point, we had the section prior about records. It doesn't really mention sharing of records at all. So unless no records may be shared, then something must be addressing confidentiality of records and when records get shared. And I am assuming the intent was for this section to be addressing both information contained in the records and the records themselves. So I think that there is.
I actually don't know if we could, I mean, health records are maintained in terms of confidentiality laws. And so if there was any request for health information, it would have to come in the proper way with an ROI. So we couldn't write into these regulations a mandate to share information that went against specific mandates. Does that make sense? Like we couldn't
Absolutely.
write.
I think
Yeah.
what's lacking is spelling out that the facility needs to have a procedure for that, essentially. And I mean, I think especially because defense attorneys like Joni are the ones that need to help their clients understand how to make those decisions. And if they're not spelled out in policy, how can the youth's attorney help them make those like decisions? So I think that's part of what's lacking here. I mean, I've certainly seen health records being shared from health providers to probation and the court. So if there's a procedure for that, that should be like made clear.
Well, so the way I kind of read this, and I'm so within a facility, there will be times that information will need to be shared, whether it's of a mental health nature, medical nature, having to do with the housing of the youth, safety of the staff, and ongoing programming and treatment for the youth, right? So for instance, we may have a youth that has MRSA, which is, an infection that is pretty contagious. And there are certain ways that we have to environmentally deal with that, right? So we need to let the staff know this is what's going on. This is how we're going to handle it. This is how you have to handle their clothing. This is how you want to, handle, make sure it's covered, that sort of thing. Another example might be a youth who should be taking some sort of psychotropic medication and has decided not to take it. We're not going to go and tell the staff they're supposed to be taking this because they're diagnosed with this and they're not taking it. What we might say is, this youth is under treatment and is not being compliant with treatment, and you may notice these behaviors. If you do, here's what you can do. Here's when you need to call us. Here's when you need to call 911. That sort of a thing, right? And that seems like what this section is saying. If it needs to be broken out, like in section A, I understand your point, Meredith, in terms of, what's coming, which direction, what's coming to health services staff versus what's being able to be communicated back. This doesn't replace the need for specific ROIs though. So this would just be like an informal ability to share information in the best interest of the youth within the facility. Does that make sense?
Can I ask a question about your last hypothetical?
Mhm.
So when, let's say you have a youth who's being treated with psychotropic medication, the youth stops taking the medication, and you were not going to say to staff, here's the diagnosis, whatever, but you might say, well, they're not complying with treatment. In your view, are you able to communicate that limited amount of information without an ROI?
In the best interest of the kid and treatment planning for the kid, yes.
But there's
Because-
no provision for that, like in the law that I can see that's spelled out. There's nothing, that's just, right? Like, if we're talking about the psychotherapist patient privilege, there's no exception that says best interest of the kid. And
So this wouldn't be a medication that's prescribed by the psychotherapist. This would be a medication that's prescribed by the psychiatrist, which is a doctor. So they're under medication treatment that, if they're not being compliant with, could impact their behavior, which could then impact their ability to be on the housing unit, which then could impact the overall housing unit. And so we have a responsibility within the facility to communicate that to the housing staff so that they have the ability to keep everyone safe, right? So that they can look out for certain behaviors so that they're able to deal with that youth within the milieu of the rest of the youth on the unit. So
I mean, I understand what you're saying, and I 100% agree that information in an ideal world should be communicated. What I'm pointing out is that I actually don't know if there's a legal exception to privilege like that. I think it's actually really complicated. And so that's why I'm suggesting that, one, that we tease out healthcare from mental health care, but also that we spend a lot more time thinking about confidentiality and how providers in facilities can share information with staff.
I want to say, and again, I am neither a doctor nor an attorney, but I believe, because the terminology that Kristen's using, in the best interests of the youth. I mean, we've talked about this in very broad contexts in adult detention facilities as well. I believe that there is abilities, there are requirements, provisions under HIPAA to allow certain pieces of information to be disclosed for those sorts of scenarios that we were talking about. I mean, we're often in local detention facilities, and there's markers for, I mean, when COVID was around, I mean, it still is around, but there would be a marker on a young person's or an adult person's living unit that there was communicable diseases in the area or other sorts of indications. I mean, there has to be, I mean, even in other residential settings, there has to be a way to communicate information with the staff, not just in detention facilities, but also in other residential places. And I'm Googling is not, is not an attorney.
Yeah,
but
and
I-
there are certain health and safety
Yeah.
codes that allow for sharing of information specific to communicable diseases like you're talking about.
Yeah, and it's more the information that starts going into mental health care specifically, and information that would be otherwise protected by the psychotherapist patient privilege, that isn't, where you don't have a Tarasoff concern, and there isn't some kind of danger to self or others concern, but does impact a youth's presence on the unit. Best interests of the youth is not that's not a reason to be disclosing information. Though I think that there are other legal mechanisms of doing that. And that's why I think it's worthwhile to spend some time talking about this and really fleshing out and defining what the outer boundaries of that is, so it's clear to everybody.
So Joni, just so I'm clear, because I'm not super clear, are you suggesting that the psychotherapy notes, so like the notes that the therapist is actually recording when they're in session with the youth, should be shared, that we should have a mechanism to be able to share that? Is that what you're saying?
No, that is not what I'm saying. I'm saying
Okay,
the opposite, which is those things are really, really private. And
right.
any information that's shared from what would be therapeutic notes would have to be very, very circumscribed. And
Right.
I think the way you're describing it, where you don't go into detail about a lot of things, but you say, hey, this kid is not complying with treatment, and you may notice these symptoms. I feel like that's pretty circumscribed. But I don't think that all practitioners do that. And so it's helpful to have a guideline that delineates like when that information can be shared and when it can't. But
Well,
it's just
I think that in any congregate setting like this, you're gonna have situations where information sharing is essential, right? If you have a youth that might start hurting themselves, you need to communicate that. You need to communicate to the staff who are responsible for their custody and care that you have this concern. And you may be aware of the other treatment modalities that are not in play because the youth is refusing them. But you have a responsibility to report to the staff, hey, you may see this specific behavior, and here's our recommendations, right? So in terms of this section, how do we want to proceed with this? I think it was Meredith that suggested that we take this and maybe bring it back next time. Was that you, Meredith, that said that?
That was one idea.
Because I think there's existing laws that protect, like you're saying, Tarasoff and danger to self is very, very clear.
Right.
It's all of these other gray areas that can be interpreted in a variety of different ways of benefit to the youth. And I suppose it always depends on what side of the table you're sitting on of what could be considered benefit to the youth. So aside from MOUs and information sharing agreements, very clear scopes of what that is. I think for everybody to feel comfortable, we probably have to give this section a little bit more thought in order to put some of that language in there. and maybe it is something, the language of outside of issues of safety. It requires X, Y, and Z to be able to appropriately share information. And we define information as in communications, i.e., is somebody a client, and when do they have an appointment? And that kind of we do special instructions. Yes, they can have an activity sheet. They can have if there is any restrictions for their own safety, no razors, hygiene packs. We communicate those things all the time. And we also have a very, very high percentage of participation in voluntary mental health services and very high participation in voluntary signing of releases of information. We never consider releasing. And then there's the other side of the communication, which is the actual records, which then take a little bit more of a thoughtful look about what is appropriate to disclose, even if the client does give us permission to disclose those records. So
Mhm. Yeah, and I think this section, I just pulled up my confidentiality policy, and I think that this section does leave it open for individual jurisdictions and facilities to construct their own policies around this in line with what their services are on site. But if we need to flesh it out more, then let's do that.
I think I'm glad you said that, Kristen, because I see sort of this break after the first sentence where it ends with information in section A. And so, starting a new paragraph with these policies and procedures shall address. And maybe, I don't know if Meredith or Joni, you have some way to help us, again, I just get completely lost in HIPAA. I think many people do. Because if you took out everything after multidisciplinary sharing of health information, you'd almost have enough to require the facility and the health administrator to develop those policies and procedures. They'd have to have HIPAA or whatever applicable laws regarding confidentiality side by side. And generally it's county council that validates or whatever, or approves those types of policies and procedures. So again, the task for the health administrator and the facility administrator would be, okay, multidisciplinary sharing of health information. What does that actually look like? When do we have to notify staff? What information do we need to notify, and in what order, and what's, outside of laws, what do we have to do? So the facility then comes up with the instances in which there should be multidisciplinary sharing, and then they're going to have to engage with somebody who understands HIPAA, whether it's the attorney, their county council, or some other healthcare provider, to then say, okay, these are the specific times in which we are going to notify staff. So the difference here would be calling those times out in regulation, but I don't know enough about HIPAA to apply those to every single facility.
Well, and we wouldn't just be thinking of it in terms of HIPAA. I mean, there's other like health and safety systems that we would need to, yeah.
So I don't know, and so I'm asking, I almost want to highlight the section where it says these policies and procedures shall address, and kind of highlight that and keep it separate for a moment, and then start with the first sentence and A, what are the laws, and B, what are the times in which there would be multidisciplinary sharing of health information. And then you can start applying maybe policies and procedures should address communicable diseases for one, deterioration after or decompensation after a serious mental health incident, or abruptly stopping psychotropic medications, things like that. So, you know, I'm going to take advantage of the fact that, you know, Meredith and Joni, your attorneys, and I don't know how much you know about HIPAA, but would it be possible to kind of look at it separately? What could be the applicable laws and the multidisciplinary sharing of when would it be shared? And then how could we flesh the rest of the regulation out so that an agency could develop policies and procedures using that framework? Or we could try it now in the next 18 minutes.
We need to leave open time for public comment.
Yes.
Yeah.
We were thinking, there is 11 attendees. So we were thinking we could actually, if everybody did public comment, we'd have enough time to leave 20 minutes. So we were thinking of stopping at 3:35, 3:40. Also depending on how far we get on this. I don't know that we want to start another one after this. So we can also go with the what the group feels is best.
So just to circle back around, we're gonna come back to that section A for the next meeting, perhaps.
No, I was seeing if maybe Meredith or Joni would be willing, or both of you be willing to help us flesh that out.
For next time or in the next 10 minutes?
I want it in the next 5 minutes. No, I'm just kidding. Next time.
Yeah. No, like I said, I think it's actually really, really important. So I'm happy to try to be a little bit more thoughtful about that. Sure.
Yeah, that would be helpful. And again, just the way my mind reads these regulations, you know, looking at that first sentence and then figuring out from there. Oh, and Amanda, I want to say, Amanda, why? But Amanda, why? Just popped some HIPAA stuff into the chat too.
If I could just add, like I say, it's not my wheelhouse, but it seems that last sentence, the nature and extent of information shared shall be appropriate. Seem like that last sentence being changed could kind of change the direction and give a little more direction in terms of, you know, what's allowed and what's not allowed in terms of, when I see that the nature and extent of information shared shall be appropriate to ... maybe something in there could be changed to be more specific to a certain situation when it is okay or not recommended, something of that nature. This is the suggestion. But otherwise, we can work on that, or we can move to wherever you decide.
I heard Joni saying she's going to take a stab at it.
I really do think somebody should be checking my work though, but yeah.
Oh,
That's what you all are here for.
of course. A bag full of red pens ready to go.
I also copied and pasted what you put in the chat. So after the meeting, I can put that in a Word doc and distribute it to everyone just so they have it outside of the chat.
Oh, I mean, I think we could totally scrap that. It just, yeah, I'm not, if I had to vote, I would vote to scrap that and just start again would be my vote.
Okay, so here we are, it's 3:26. Are we stopping here and then starting here next Tuesday?
That works. that works. I mean, that certainly works for us and it'll give us enough time to engage in public comment and answer any questions, and then we can really quickly go through next steps and start fresh next week. That works.
Okay.
So we will, actually, why don't I say this before we start with public comment? Do any of the members have questions or comments or anything to share before we move into public comment? Again, we don't have anybody in the room, so if people can raise their hands, I believe it's Howie is going to call out people name by name, and then we'll have people provide their public comment. We'll have a timer on the board for 2 minutes, and if you all are ready and we have some hands raised, we can start with public comment. So go ahead and raise your hands.
We have no public comments at this time.
Okay. Any further comments by work group members?
It also looks like we're going to get into releasing of healthcare records and summaries in a very short order, because not only do we have the confidentiality and the transfer of healthcare summary and records and the release of healthcare records, so I don't know if we're going to run into some of the same discussions, but if we do want to maybe think about it in that, how might HIPAA or some of these other procedural stuffs impact our, and it might become very obvious once we really look at and make some agreements about 1407 as it relates to 1408, 1408.5.
Yeah, that would be fantastic if I think I would call that homework for all of us to look at those and any information we can gather about anything that applies, if it's HIPAA or another applicable law, refreshing our memory with the comments, the public input that's in the back of our I mean, I have a physical binder that's in our briefing material. That would be helpful, and we can yeah, and think about, now that people have seen how the process works, coming with some proposed language is helpful too. And yeah, it's an interesting place to start for sure. I'm happy to also then give people the gift of time. We can pick up next week. I believe it's next Tuesday. Is it next Tuesday? There's a hand up.
Tuesday,
Oh,
same time.
fantastic. We have a public comment.
Hello, everybody. This is Nancy Juarez with the Center on Juvenile and Criminal Justice. Thank you for all the hours spent today. Unfortunately, I was not able to catch the majority of the meeting, but I will be sure to watch the recording. I did hear that we were speaking about confidentiality, and I just wanted to offer like an antidote. When we were working and gathering information on the situation in DJJ, the Division of Juvenile Justice, CJ, we were alarmed to find out that youth that had COVID did not have their parents notified. And when we had spoke with the leadership at DJJ, they had shared that it was because they did not sign a release of information form. But when we spoke with young people, they did not even know that such form existed in order for them to sign it and their parents to know. So their parents had no idea that their children were in isolation, did not know that they had COVID, did not know if they were being sent to the hospital. They just did not know what was going on because they did not, their kids didn't sign this form that they didn't know existed. So I just wanted to offer that. I'm not sure where we left off in the work group, but I know that was a situation in DJJ that we didn't really come to a resolution there. And now that they're closed, just moving forward, how we can avoid incidences like that. So thank you again for the time, for all the hours spent, for the discussion, the dialogue, and for this process. I appreciate it. Thank you.
No more, that was it. No more raised hands.
Allison, you're muted. I think you might be, or not muted, but I'm not hearing.
I did not have my microphone on. I said something very profound. I was just saying if there are no other comments, then we can close this meeting and regroup next Tuesday, starting with 1408. And if everybody could take a, look at these regulations where we're starting and seeing how things have gone, we can just jump in and do some productive work next week as well. And we thank everybody, especially Kristen, for their time and commitment to this process. It's really important that we have all of us here, and we really appreciate all of our work group members and our members of the community that spend the time to make these regulations, improve these regulations as best we can. So thank you.
Thanks, everyone.
Thank you. Take care.
Thanks. Bye.